Okay, I'm going to read from chapter 5, Interrogations and Confessions, section 4, Applying and Explaining Miranda. And this is a 2013 case. Justice Alito announced the judgment of the court and delivered an opinion in which the Chief Justice and Kennedy join. The police asked defendant to come to the police station to clear himself as a suspect in a murder case. When the defendant arrived at the station, he was not in custody. He was free to leave at that time. As a result, he was not given any Miranda warnings. Defendant was asked a number of questions and answered them. Then he was asked whether the shotgun from his home would match the shells recovered at the scene of the murder. At this point, the defendant declined to answer. Instead, he looked down at the floor, shuffled his feet, bit his bottom lip, and clenched his hands in his lap. After a few moments of silence, the defendant answered other questions. During the prosecutor's closing argument, he used the defendant's reaction when questioned earlier as evidence of his guilt. He pointed out to the jury that the defendant had remained silent when asked about the shotgun. The prosecutor told the jury that an innocent person would not have reacted the same way. Instead, an innocent person would have denied that he was involved. He would have said, "I wasn't there," but Salinas didn't respond that way. The court noted that it granted certiorari to resolve a division of authority in the lower courts over whether the prosecution may use the defendant's assertion of the privilege against self-incrimination during non-custodial police questioning of the privilege against self-incrimination during non-custodial police questioning of a suspect as part of its case in chief. However, because the defendant never did invoke the privilege during the police questioning of him, the court found it unnecessary to reach that question. The privilege against self-incrimination is an exception to the general rule that the government has the right to everyone's testimony to prevent the privilege from shielding information not properly within its scope. We have long held that a witness who desires the protection of the privilege must claim it as the time relies on it. Quoting Minnesota versus Murphy, 1984. Interesting outcome here. The requirement ensures that the government is put on notice when a witness intends to rely on the privilege, so that it may either argue that the requirement that with privilege, but neither. We held in Griffin versus California, set forth later in the book, that a criminal defendant need not take the stand and assert the privilege at his own trial. That exception reflects the fact that a criminal defendant has an absolute right not to testify. Because the defendant had no comparable and qualified right during his interview with the police, his silence falls outside the Griffin exception. Second, we have held what a witness's failure to invoke the privilege must be excused where governmental coercion makes his forfeiture of the privilege involuntary. Thus, in Miranda, we said that a suspect who is subjected to the inherently compelling pressures of an unwarned custodial interrogation need not invoke the privilege. So let's go back one page to Minnesota versus Murphy. Murphy, a probationer, arranged to meet with his probation officer as she had requested. He then admitted he had committed serious crimes a number of years earlier. A 6-3 majority per white concluded that Murphy could not claim the in-custody exception to the general rule that the privilege against self-incrimination is not self-executing. Any compulsion Murphy might have felt from the possibility that terminating would have led to revocation of probation was not comparable to the pressure that on a suspect who was painfully aware that he literally cannot escape a persistent custodial interrogation. Who knew? That's very interesting, though. So we got some case law here. We got Griffin. We've got Murphy. And Miranda. So next paragraph. However, as the defendant himself acknowledges, he agreed to accompany the officers to the station and was free to leave at any time during the interview. We have before us no allegation that the defendant's failure to assert the privilege was involuntary. And it would have been a simpler matter for him to say that he was not answering the officer's question on Fifth Amendment grounds, but he failed to do so. The prosecution's use of his non-custodial silence did not violate the Fifth Amendment. Our cases establish that a defendant normally does not invoke the privilege by remaining silent. We have also repeatedly held that the express invocation requirement applies when an official has reason to suspect that the answer to his question would incriminate the witness. Thus, in Murphy Supra, we held that the defendant properly admitted at trial because he failed to invoke the privilege. In reaching the conclusion, we reject the notion that a witness must put the government on notice by formally availing himself of the privilege only when he alone is reasonably aware of the incriminating tendency of the questions. So this is quite literally pleading the fifth. Now, I don't understand. I don't understand because the defendant himself acknowledged he agreed to accompany the officers. So was he ever given the Miranda when he was just, and he was free to leave at any time. So if he was free to leave at any time, I guess they're saying it's no, because like he needs to be given the Miranda to know that he needs to elect to exercise his rights. So was he given the Miranda or not? Which I want to doubt that he was, because he was just going to clear his name. He could have left whenever he wanted. Was it really an interrogation? So I don't understand why that wasn't given. So that's what I'm a little bit confused about, is that I don't know if Miranda was given. Anywho, the defendant does not dispute the vitality of either of those lines of precedent, but instead argues that we should adopt an exception for the cases at their intersection. Okay. Defendant would have us hold that although neither a witness's silence nor official suspicions are enough to excuse the express invocation requirement, the invocation requirement does not apply where a witness is silent in the face of official suspicions. Such a view would do little to protect those genuinely relying on the Fifth Amendment privilege while placing a needless new burden on society's interest in the admission of evidence as protective of a defendant's guilt. The defendant's proposed exception would also be very difficult to reconcile with the case that I'm supposed to be covering. There we held in the closely related context of post-Miranda silence that a defendant failed to invoke the privilege when he refused to respond to police questioning for 2 hours and 45 minutes. If the extended custodial silence in that case did not evoke the privilege, then surely the momentary silence in this case did not do so either. The dissent attempts to distinguish Burgess by observing that it did not. That's actually a really good comparison of case law. The dissent attempts to distinguish Burgess by observing that it did not concern the admissibility of the defendant's silence, but instead involved the admissibility of his subsequent statements. But regardless of whether prosecutors seek to use silence or a confession that follows, the logic of Burgess applies with equal force. The suspect who stands mute has not done enough to put the police on notice that he is relying on the Fifth Amendment privilege. Defendant and the dissent also maintain that release on the Fifth Amendment privilege is most likely explanation for silence in a case such as this one, but probably Doyle versus Ohio. Defendant alone knew why he did not answer the officer's question, and it was therefore his burden to make a timely assertion of the privilege. Defendant suggests that it would be unfair to require a suspect unschooled in the participation of legal doctrine to do anything more than remain silent in order to evoke his right to remain silent. But popular misconceptions, notwithstanding the Fifth Amendment guarantees that no one may be compelled in any criminal case to be a witness against himself, does not establish an unqualified right to remain silent. A witness's constitutional right to refuse to answer questions depends on his reason for doing so. During a non-custodial police interview will prove unworkable in practice. Notably, defendant's approach would produce its own line-drawing problems, as this case vividly illustrates. When the interviewing officer asked the defendant if his shotgun would match the shell casings found at the crime scene, the defendant made movements that suggested surprise and anxiety. At precisely what point such reactions transform silence into expressive conduct would be difficult and recurrent question that our decision allows us to avoid. Defendant worries that officers could unduly pressure suspects into talking by telling them that their silence could be used in future prosecution. But as defendant himself concedes, police officers have done nothing wrong when they accurately state the law. We found no constitutional infirmity in government officials telling the defendant and Murphy that he was required to speak truthfully to his parole officer. And we see no greater danger in the interview tactics the defendant identifies. Justice Thomas, with whom Scalia joins, concurring in the judgment. In my view, Salinas' claim would fail even if he had invoked the privilege because the prosecutor's comments regarding his precustodial silence did not compel him to give self-incriminating testimony. And in versus California, this court held that the Fifth Amendment prohibits a prosecutor or judge from commenting on a defendant's failure to testify. Salinas argues that we should extend Griffin's no adverse inference rule to a defendant's silence during the precustodial interview. I have previously explained that Griffin lacks foundation for the Constitution's text, history, or logic and should not be extended. I adhere to that view today. At the time of the founding, English and American courts strongly encouraged defendants to give unsworn statements and drew adverse inference when they failed to do so. Given Griffin's indefensible foundation, I would extend it to a defendant's silence during a precustodial interview. Justice Breyer, with whom Justice Ginsburg, Justice Sotomayor, and Kagan joined dissenting. In my view, the Fifth Amendment here prohibits the prosecution from commenting on the petitioner's silence in response to police questioning, and I dissent from the court's contrary conclusion. To permit a prosecutor to comment on a defendant's constitutionally protected silence would put the defendant in an impossible predicament. Again, I think the court was saying was that this was not constitutionally protected silence because we didn't invoke the right of constitutionally protected silence. So that right there is the fallacy. He must either answer the question or remain silent. If he answers the question, he may well reveal, for example, prejudicial facts, disreputable associates, or suspicious circumstances, even if he is innocent. If he remains silent, the prosecutor may well use that silence to suggest a consciousness of guilt. And if the defendant then takes the witness stand in order to explain either his speech or his silence, the prosecution may introduce, say, for impeachment purposes, a prior conviction or that the law would otherwise make admissible. Thus, where the Fifth Amendment is at issue, to allow comment on silence directly or indirectly can compel an individual to act as a witness against himself. And very much what the Fifth Amendment forbids. And that is similarly so whether the questioned individual, as part of his decision to remain silent, invokes the Fifth Amendment explicitly or implicitly, through words, through deeds, or through reference to surrounding circumstances. It is consequently not surprising that this court, more than half a century ago, explained that no ritualistic formula is necessary in order to invoke the privilege. Thus, a prosecutor may not comment on a defendant's failure to testify at trial, even if neither the defendant nor anyone else ever mentions a Fifth Amendment right not to do so. So, even though this doesn't really sound right, there is no ritualistic formula necessary in order to invoke the privilege, right? It's just given to us by the Constitution is what they're saying. Thus, a prosecutor may not comment on a defendant's failure to testify at trial, even if neither the defendant nor anyone else ever mentions the Fifth Amendment right not to do so. Okay, fine. It's fair. Circumstances not in defendant's statement tie the defendant's silence to the right. Similarly, a prosecutor may not comment on the fact that a defendant in custody after receiving Miranda warnings stood mute. Regardless of whether he claimed his privilege in so many words, again, it is not any explicit statement, but instead the defendant's deeds, silence, and circumstances received the warnings, which we hope to be in the facts. I don't know, maybe not. That tie together, is this a material fact? Question mark. Tie together silence a constitutional right. Most lower courts have so construed the law even where the defendant, having received Miranda warnings, answers some questions while remaining silent as to others. The cases in which this court has insisted that the defendant expressly mention the Fifth Amendment by name in order to rely on its privilege to protect silence are cases where, 1, the circumstances surrounding the silence, unlike the present case, did not give rise to an inference that the defendant intended by his silence to exercise his Fifth Amendment rights, and 2, the questioner, greeted by the silence, again, unlike the present case, had a special need to know whether the defendant sought to rely on the protections of the Fifth Amendment. In such cases, the government needs to know the basis for refusing answers so that it may either argue that the testimony sought could not be self-incriminating or cure any potential self-incrimination through a grant of immunity. Next paragraph. Perhaps most illustrated is Jenkins versus Anderson, 1980, a case upon which the plurality relies and upon which the Texas Court of Criminal Appeals relied almost exclusively. Jenkins killed someone and was not arrested until he turned himself in 2 weeks later. On cross-examination at his trial, Jenkins claimed that his killing was in self-defense after being attacked. The prosecutor then asked why he did not report the alleged attack, and in closing argument suggested that Jenkins' failure to do so cast doubt on his claim to have acted in self-defense. We explained that this unusual form of pre-arrest silence was not constitutionally protected from use at trial. Perhaps even more aptly, was not Justice Stevens' concurrence noted that the privilege against compulsory self-incrimination is simply irrelevant in such circumstances. How would anyone have known that Jenkins, while failing to report an attack, was relying on the Fifth Amendment? And how would the government have had any way of determining whether this claim was valid? In Jenkins, no one had any reason to connect the silence to the Fifth Amendment, and the government had no opportunity to contest any alleged connection. Interesting. Okay, so still further afield from today's case are Murphy and Gardner. Cases the term. See Gardner versus United States, 1976. At the time of providing answers, neither circumstances nor deeds nor words suggested reliance on the Fifth Amendment. Murphy simply answered questions posed by his probation officer. Gardner simply filled out a tax return. They did not argue that their self-incriminating statements had been compelled in violation of the Fifth Amendment until later at trial. The court held that those statements were not compelled. The circumstances indicated that the defendants had affirmatively chose to speak and write. Thus, we have two sets of cases. One where express invocation of the Fifth Amendment was not required to tie silence to its protections, and another where something like express invocation was required because circumstances demanded some explanation for the silence or the statements in order to indicate the Fifth Amendment was at issue. There is also a third set of cases that may well fit into the second category, but where the court has held that the Fifth Amendment both applies and does not require express invocation despite ambiguous circumstances. The court in those cases has made clear that an individual, when silent, need not expressly invoke his Fifth Amendment if there are inherently compelling pressures not to do so. The court held that no explicit assertion would by law have cost police officers their jobs. Similarly, held that no explicit assertion of the Fifth Amendment was required where, in the course of an investigation, such assertion by law have cost police officers their jobs. Similarly, this court did not require explicit assertion in response to a grand jury subpoena where that assertion would have cost two architects their public contracts or a political official his job. Lefkowitz versus Turley. Lefkowitz versus Cunningham. 1973, 1977. The plurality refers to one additional case, namely Berguis versus Tompkins, but that case is here besides the point. In Berguis, the defendant was in custody. He had been informed of his Miranda rights, and he was subsequently silent in the face of 2 hours and 45 minutes of questioning before he offered any substantive answers. The court held that he waived his Fifth Amendment rights and respected his later speech. The court said nothing at all about a prosecutor's right to comment on his preceding silence, and no prosecutor sought to do so. Indeed, how could a prosecutor lawfully have tried to do so? Given this court's statement in Miranda itself that a prosecutor cannot comment on the fact that after receiving Miranda warnings, the suspect stood mute. Right, so Miranda is controlling, in my view. We end where we begin. No ritualistic formula is necessary in order to invoke the privilege. Much depends on the circumstances of the particular case, and most important circumstances being, one, whether one can fairly infer that the individual being questioned is invoking the amendment's protection. Two, if that is unclear, whether it is particularly important for the questioner to know whether the individual is doing so. And three, even if it is, whether in any event there is good reason for excusing the individual from referring to the Fifth Amendment, such as inherent penalization simply by answering. So, applying these principles to the present case, I would hold that Salinas need not have expressly invoked the Fifth Amendment. The context was that of a criminal investigation. Police told Salinas that and made clear that he was not a suspect. His interrogation took place at the police station. Salinas was not represented by counsel. The relevant question about whether the shotgun from Salinas' home would incriminate him amounted to a switch in subject matter, and it was obvious that a new question sought to ferret out whether Salinas was guilty of murder. These circumstances give rise to reasonable inference that Salinas' silence derived from an exercise of his Fifth Amendment rights. This court has recognized repeatedly that many, indeed most, Americans are aware that they have a constitutional right not to incriminate themselves by answering questions posed by the police during an interrogation conducted in order to figure out the perpetrator of a crime. See Dickerson versus United States. The nature of the surroundings, the switch of the topic, and the particular question all suggested that the right we had and generally know we have was at issue in the critical moment here. Salinas, not being represented by counsel, would not likely have used the precise words Fifth Amendment to invoke his rights because he would not likely have been aware of technical legal requirements, such as a need to identify the Fifth Amendment by name. But at the same time, the need to characterize Salinas' silence as based on the Fifth Amendment is supported here by the presence in full force of a predicament I discussed earlier, namely that of not forcing Salinas to choose between incrimination through speech and incrimination through silence. That need is also supported by the absence of any special reason that the police had to know with certainty whether Salinas was in fact relying on the Fifth Amendment, such as certainty to doubt that there really was a risk of self-incrimination, or whether to grant immunity. Given these circumstances, Salinas' silence was sufficient to put the government on notice of an apparent claim of the privilege. That being so, for reasons similar to those given in Griffin, the Fifth Amendment bars the evidence of silence admitted against Salinas and mentioned by the prosecutor. I recognize that other cases may arise where facts and circumstances surrounding the individual's silence present a closer question. The critical question whether those circumstances give rise to a fair inference that the silence rests on the Fifth Amendment will not always prove easy to administer, but that consideration does not support the plurality's rule-based approach here, for the administrative problems accompanying the plurality's approach are even worse. The plurality says that a suspect must expressly invoke the privilege against self-incrimination. But does it really mean that the suspect must use the exact word, Fifth Amendment? How can an individual who's not a lawyer know that these particular words are legally magic? Nor does the Solicitor General help when he adds that the suspect may make a claim in any language that the questioner may reasonably be expected to understand as an attempt to invoke the privilege. What counts as making the claim? Suppose the individual says, let's discuss something else, or I'm not sure what I want to answer that, or suppose he just gets up and leaves the room. How is simple silence in the present context any different? The basic problem for the plurality is that an effort to have a simple, clear, explicit statement rule poses a serious obstacle to those who, like Salinas, seek to assert their basic Fifth Amendment right to remain silent. For they are likely unaware of any linguistic detail. At the same time, acknowledging that our case law does not require use of specific words leaves the plurality without the administrative benefits it might hope to find in requiring that detail. Far better, in my view, to pose the relevant question directly. Can one fairly infer from an individual's silence and surrounding circumstances the exercise of the Fifth Amendment's privilege, the need for simplicity, the constitutional importance of applying the Fifth Amendment to those who seek its protection, and this court's case law all suggest that this is the right question to ask here, and the answer to that question in the circumstance of today's case is clearly yes. For these reasons, I believe the Fifth Amendment prohibits a prosecutor from commenting on Salinas' silence, and I respectfully dissent from the court's contrary conclusion.